folks, I'm sure, are going to be trickling in as we go. Just a couple announcements before we get underway. I'm going to pass around a sign-in sheet. Please write and print your name and your email. Just helps me to keep track of who attended, and if anybody wants to receive a copy of the PowerPoint slides. There we go. I'm happy to email them to you. Several people mentioned last week that they would like copies. There are about 15 copies printed out in the back on that table. So please feel free to pick one up. And there's also flyers as a little teaser about what we're doing in January. But with that, I'm going to pass it on to Mary.
Okay. Well, thank you all for coming back. I seem to bring snow on Sundays. I don't know what's not happening, but it does. Just a real quick recap. Last week we talked about powers of attorney for healthcare, powers of attorney for property, living wills, and things like posts, which are physician orders, regarding resuscitation and hydration. Those are all effective during your lifetime. Those help manage your disabilities if you become disabled. And they all, the authority there ceases to exist when you die, except for your healthcare agent, if you have given them the right to dispose of your remains, can do that. So my understanding. How's that better?
Can everybody hear?
Yeah. Okay. So, you know, if you have questions about some of that stuff from last week, I'm happy to answer questions. The materials that you see on the screen are the materials that you can pick up. So there's a lot of kind of explanation and notes there. This week, we're going to talk about kind of estate planning basics, wills, trusts, and beneficiary designations, and kind of how they work together and sometimes don't. It's nice together. So what's the purpose of doing your estate plan? It's really to control the use and disposition of property, both during your lifetime and after your death. It involves transferring your property to or for the benefit of the people you want to be beneficiaries. So there are, you know, kind of four categories of what estate planning involves. It involves people, you and your chosen beneficiaries. Property, which can be property that passes through a probate estate or not, and we'll talk a little bit about what passes through a probate estate and what doesn't. It can hold the timing. It can be during your lifetime. It can be at your death. And it also typically addresses taxes. So, like I said last week, we deal in two things that most people are very uncomfortable talking about: death and taxes. We try and do it in a kind of straightforward way. So let's start with just some simple definitions. What is a will? So in Illinois, it's a writing. It's signed by the testator, you, and witnessed by two or more credible persons. Those people should not be takers under your will. They should be independent of your beneficiaries. So your will is completely amendable, revocable, changeable by a testator at any time during your lifetime. And typically, when you execute a new will, you revoke the prior will. So there's no confusion over what the terms are and what controls. Wills typically include dispositive provisions. So I give my property to this person, or I give my property to this trust. Typically appoints an executor, and if appropriate, if you have minor children, it would appoint a guardian for a minor, or in the case of a disabled child. And then there's a section of the will that kind of provides instructions for how to administer the estate, what powers the executor has. Wills can, within the four corners of the document, can create trusts. Those are called testamentary trusts, or it can add to an existing trust, typically a revocable trust that you created at the same time you create the will. If it just takes everything and adds it to an existing trust, that's called a pour over will, because it takes everything that you own individually and pours it over into your trust. If you don't have a will, the state of Illinois has one for you. You may or may not like it. It typically leaves, if you're married with children, 50% of the spouse and 50% of children, which maybe that's what you want, but if you have minor children, probably not what you want, because that would then require a guardianship for the minor children. So that's a will, and wills can be lengthy, complex documents if they are creating testamentary trusts, or they can be 4 or 5 pages of just, making the dispositive provisions, naming an executor, giving some rudimentary powers, and boom, you're done. And then pours it in the trust. So trusts are a method of holding ownership to property with legal title to property in the name of a trustee, but the equitable or the beneficial title in the name of a beneficiary or beneficiaries. Trusts can cover a lot of ground. They can be created during your lifetime, which are vivos trusts, created at your death under a will, that's a testamentary trust. They can be irrevocable or revocable. And people often use irrevocable trusts to do some of the more complex tax planning that we'll talk about in a little bit. Probably the most common trust is a revocable or living trust. You create it when you're alive. It's for your benefit and your benefit only while you're alive. And at your incompetency, there are provisions to care for you and any people who are dependent upon you. And then at your death, it directs the distribution of property to either people or additional trusts that it creates for the benefit of the people that are your beneficiaries. So one of the main advantages of having a revocable trust is you can use that revocable trust to manage assets in the event of your disability. So your successor trustee would step in and be able to manage the assets owned by the trust. When you die, your successor trustee can step in, and the assets that are owned by the trust avoid probate. Yes.
You fund a trust, the trust owns the asset.
Yes.
It's not the asking. It's basically the trust owns the asset. The trustee is basically having the restriction about what happens with the property that's in the trust.
Okay, so the question is, how does the trust, when you fund it during your lifetime, does the trust own it? Does the trustee own it? How is it titled? Is that your question?
The question is, the trustee never owns the trust. It's basically given the responsibility and jurisdiction to manage the trust asset.
Well, it does depend on state law. So some states, title to assets in a trust is actually, like Joe Smith as trustee of the Stephen Smith Trust. In some states, it is the Stephen Smith Trust is the record title of ownership.
What is it?
Illinois is typically in the name of the trust. And what for example, what a lot of banks will do is put it in your name, trustee of your revocable trust. So you see a little bit of a mix in Illinois. But the idea is the trust and, the trust controlled by the trustee owns the bare legal title, but it's for the benefit of the beneficiaries. And the trustee has to act with what's called a fiduciary duty, putting the interest of the beneficiaries of the trust as primary. So that, you kind of have this bifurcated ownership, the legal title and the beneficial title.
You can have the trustee and beneficiary.
Yes, for your revocable trust, typically the trustee and the beneficiary are the same during your lifetime. And then a successor trustee takes over at incapacity or death.
I'll take a little time on this.
No
So,
problem.
given that bifurcation that you just articulated, what is the distinction between the two with respect to what the trustee can do and not do? Or is it all the same based on the provisions in the trust of the arms?
Yeah, so the trustee's actions are controlled by governing law and the trust instrument. So if the trust instrument says you can do everything except you can't do, like, for example, you cannot invest in crypto, right? You know, typically an individual could make any investment decision that they want to do. But the terms of the trust may limit the powers of a trustee, or they may, you know, grant very, very broad, expansive powers. Because as human beings, we have a hard time thinking through every iteration that's out there. Most people are more comfortable having the broader powers granted to a trustee so that the trustee could do pretty much anything you could do. But they have to do it for the benefit of the beneficiaries.
Still going back to the question, you talked about some states have, you know, the trustee having different distinctions of the itself.
Yeah.
So is there any attitude trustee can do under each one of the situations that will be the same fiduciary standard?
It's all the same. Yeah, no problem. The third kind of definitional thing I want to get through, and I do appreciate very much an interactive discussion here. So as with last week, please feel free to stick your hand up, ask questions. It's much more fun to have a conversation instead of me just talking. So the third kind of category of things that impact your estate plan are beneficiary designations. So that's a designation filed with the holder of the property, the custodian of the property, directing who shall own that after your death. So we see them all the time, right, with life insurance policies, pensions, 401ks, IRAs. They're becoming more common with banks, and they are either called transfer on death or pay on death accounts. And beneficiary designations are great because it avoids probate. Where they're not great is when you sign a beneficiary designation or an account is established with a TOD or a POD, and it actually conflicts with the planning you're trying to do within the rest of your estate plan. So you have to be careful with beneficiary designations to make sure that it's actually going to match up to the rest of your estate plan. And it's one of those things that, you know, insurance agents, retirement account holders, banks will say, oh, we'll just set this up as a POD or a beneficiary designation. And it's easy for them. But you need to stop and think, does this make sense? You know, I should probably talk to my estate planner to make sure that the whole picture works. And then one final category, I think it's final, is transfer by operation law. So many people here may own a house as a joint tenant with a right of survivorship with a spouse, or perhaps tenancy by the entireties with a spouse. Tenancy by the entireties is available only to married couples for real estate in Illinois, and it protects the house from claims of a single creditor. It has to be a joint creditor of the spouse to be able to reach property held in tenancy by the entirety. So it's a way to protect a spouse from another spouse running up a bunch of debt, and then the one who didn't know about it who's in the house. But if you own property as joint tenants with right of survivorship or in tenancy by the entireties, title passes by operation of law at the death of the first joint tenant or tenant by the entireties who die. And it's not subject to your other estate planning documents. I talked a little bit about probate property. So probate property is anything that you individually own. It's not in a trust, it's not covered by a beneficiary designation, it's not a joint tenancy property, it's either in your individual name, or you are a tenant in common, which has no survivorship rights. So that undivided tenancy in common. And only those properties are subject to the court's administration in probate. Everything else passes outside of probate. So your non-probate property is a home owned as tenants in common, joint tenants with right of survivorship, or not tenants in common, joint tenants with right of survivorship or tenants by the entirety. Life insurance has a beneficiary designation. IRA retirement plans usually have a beneficiary designation. Bank accounts that are TOD or POD, and property held in trust. Now, if it's something that typically has a beneficiary designation and you never did a beneficiary designation, that will flow through usually by operation of the contract to a probate estate. So if you have a very, very old beneficiary designation and the person or persons that you designated have predeceased you and you don't change it, you could end up with beneficiary designation assets going to a probate estate and requiring a probate estate. Yeah.
Could you reason why some hold assets with tenants in common as opposed to other ways of titling assets?
Yeah, the question is, why would you hold assets as tenants in common rather than titling it with some kind of right of survivorship? The answer for that is that's often more of a business relationship with your joint tenant than a familial relationship with your joint tenant. Sometimes you might have people that are business partners or perhaps more distantly related that own a piece of real estate and they hold it as tenants in common because each wants to hang on to and be able to control how their share, if it's two people, how their 50% share would pass. So that's the main reason. There are better ways to do it. You could hold a piece of real estate in an LLC and have the interests of the LLC, subject to your estate plan. But, kind of the old way to do it was tenants in common. Yes.
There are typically designations in the trust of the will to pay your executor something for the work that they may do. Is that standard or is that not at all?
The question is, are there designations in your will or trust to pay your executor or your trustee? The answer is typically yes. Some people will say, oh, but I don't want a child of mine who is a beneficiary of the estate to take a fee on top of their share of the estate. So sometimes there's a prohibition. And usually if it is a prohibition, it's a prohibition in that sense, not broadly. So again, that's one of those things that you can customize depending on what makes sense for your situation and who you're asking to be a beneficiary. Sometimes, to be a trustee. Sometimes if you're asking an attorney or an accountant to be a trustee, they will say, I'm happy to do that, but I would like to be able to charge at my regular rate for that. And so sometimes I see people putting that kind of language into a trust instrument.
If there is no provision for an executor, for instance, can an executor be reimbursed? And what does it take? A change of the document or a letter?
No, but the question is, if your documents don't cover paying a executor or trustee, can they be reimbursed? Absolutely can be reimbursed for expenses. And Illinois law allows a reasonable fee if it's not prohibited in the document. So if it just got left out, typically what will happen is in a probate estate, there'll be a fee petition And they will, they will lay out all the things that they've done and how long it's taken them and ask the court for fees. If it's a trust, typically at the start of the administration of the trust, the trustee will say, look, this wasn't covered in this document under Illinois law. I'm entitled to fees. This is my proposed fee schedule. And get agreement from the beneficiaries that that's a fair fee. And then can go ahead and charge fees according to that schedule.
And what sort of range of fees? Is it usually a percentage or hourly?
Question is, how do people charge? It depends. I mean, you see everything from zero to a percentage of assets under management, which is typically what corporate fiduciaries will charge. And that will cover, there's usually an asset management piece and then a piece that deals with, kind of the more specific things to estate administration. So, paying, preparing tax returns and paying the taxes, collecting assets. So there'll be like an administration fee. And that's typically, as I said, that's typically discussed very early in the process. So the beneficiaries understand what the proposed fee would be. And, if they object. They have to have a chance to understand and object. Again, that's part of the fiduciary duty, right? You can't just come in at the tail end and say, oh, by the way, I've charged a boatload of money and there's nothing you could do about it. Does that answer your question?
Well, I was thinking of numbers.
It's tough.
You said zero.
Yeah, it is tough. And I haven't done an estate administration in probably 12 to 15 years. The probate court, if they're looking at a fee petition, is looking at something, maybe in the 50 to 75 to maybe $100 an hour range. At least that's what it was way back in the day. But it's a broader question of how complex was this? How much time did it take? Are there extraordinary things about this? You get into a will contest and there's going to be a lot more in fees. But individuals acting as a fiduciary generally tend to be allowed lower fees than a professional fiduciary.
Is it also fair to say that if you want to incentivize the trustee to pay attention, maybe less responsible as opposed to bring his key?
That is absolutely true. Trustees who are told they cannot be paid will typically, well, not typically. Professional trustees would absolutely say, well, I'm sorry, we can't do this, it's for nothing. But even family members may say, you know what, this is a huge amount of work. Come on, I don't want to do this. And that's fair. I didn't see both in private practice, actually, I never in private practice put in a provision that said you cannot be paid. And when I was in-house at a couple of large corporate fiduciaries, I reviewed a lot of trusts, and there were very few trusts that had limitations on trustees' fees, and those typically were done in the early 1900s, and they would like put the fee schedule in, and it would say, you get $200 for this, and we'd be like, oh, okay, we got to fix this before we can take that. But yeah, you're right, it would disincentivize in a lot of cases, so I wouldn't recommend that. Yeah.
Did you ever see fees, like as a percentage of the assets? Like, half a percent or, 75 basis points?
Yeah, I mean, corporate fiduciaries typically charge percentage of assets for managing the assets. That's very typical. I have seen, let me see, in practice, I saw a few times fees like half of what the corporate fiduciary would charge or a quarter of what the corporate fiduciary would charge. Most of the time, it really was just kind of eyeballing how much work is involved and what's a reasonable hourly rate, take someone away from doing something else, right? A lot of times the people that are typically asked to be a trustee or executor are either lawyers, accountants, or family members, if it's not a corporate fiduciary. And so, the question is what's fair? And most of the time, if it's an accountant or a lawyer, they're charging their regular rate. And that's, people just say, okay, that's fine, you're doing all this work. If it's a family member, that gets interesting. Family dynamics can get very interesting. And so, if it's an individual, I always recommend get everyone around the table, talk about what's involved, and a lot of lawyers will send kind of a multi-page overview of this is what's involved, right? You have to collect all the assets, you have to establish new accounts, get everything under management. You're gonna have to go through an appraised tangible personal property, you're gonna have to sell real estates, supervise the process of people selecting the tangible personal property that they want. Get rid of whatever people don't. You're gonna have to clean out a house. There's a lot of, fairly heavy grunt work there.
That's for an executor.
Executor or trustee, whoever is doing post-death administration, typically, at least on the second dies, a lot of that extra stuff. The first spouse to die, it's usually just transferring in assets and, filing a tax return. So I think what we used to do in practice is walk people through what was involved. And when it was a sibling, get an agreement that this is a lot of extra work and they should be able to charge for it. And they will track their time and will show you in advance. You'll have an opportunity to object.
Could you opine, given your experience in the banking school, benefits of lack of establishing a corporate trustee for this?
Sure. So the question is, what are the benefits or lack thereof for selecting a corporate trustee? I think there are a lot of benefits to selecting a corporate trustee. It is particularly helpful with challenging family dynamics. I can't tell you how much it helps kind of take the temperature down. If everybody's talking to a professional trustee, there are multiple people sitting on a committee looking at a request. There is a detailed analysis of a request and a statement, back to the requesting person, I want a distribution for X, Y, or Z from a trust. It can be hugely helpful. You have professional financial management. You have professional preparation of estate tax returns and fiduciary income tax returns. And frankly, it's a lot of work for individuals. Most individuals, even if they want to take on the role, will hire agents, right? And you can hire a corporate fiduciary to be your agent for estate administration, but you're still the trustee. So, let's say my mom dies and I decide I'm going to hire another trust company to be my agent, and they'll do all the, kind of the back office, collecting, paying taxes, all of that stuff. But I still get to be the final decision maker. I think there can be a lot of benefit there.
You have the successor issues. When a trustee gets sick,
Yes,
or you say, hey, all my 4 kids, they get along great.
until they don't.
Turkey, Thanksgiving, and so.
Right. Yeah. The point is about the constant succession there. I mean, even if the individual trust officer that you have been working with is leaving, there are a lot of people who have already touched it. They know what's going on. And, there's that continuity there. There's much less opportunity for mischievous interference, maybe from in-laws or the like. So there, I see a lot of benefit to it. And I saw, I was in the legal department, but I saw trust officers sitting down with family members and really helping them work through very difficult issues where people were at loggerheads. And the bank is kind of Switzerland, right? Saying, okay, this is, I hear you and I hear your sibling, and, this is what we propose and this is why. And that can kind of help bring down the temperature. Doesn't always, it doesn't mean that people don't get mad enough over, I think one case when I was a young attorney, we had 3 brothers fighting over who got the purple china. Literally, I'm not making this up. And it started with a mediation at 10 a.m. and after midnight, the deputies at the Daily Center threw everybody out and said, you have to go home. And they still hadn't resolved who got the purple china, kind of, because that was really who was mom's favorite.
But they always have to agree in fact.
You go to
Yeah.
replacement.com.
Replacements.com, exactly. But you see a lot of, and I'll get to you in just half a second. You see a lot of unresolved issues that just come exploding into the open when a parent dies. And particularly if it's the second parent and that was the parent that was the glue holding the siblings together as a more cohesive family unit. So particularly in situations where you're a little concerned about how well kids are gonna get along after you're gone, a corporate trustee can really help on that. And you had a question.
Yes, thanks. Mine goes back to probate property versus no non-probate property. If one of the children is on the title with the parent on a piece of property, not living with them, how could that, what is your suggestion and there's another.
Okay, so parent is on title with child 1.
Correct,
Child 2 is not on title.
correct. And aware of the
Nobody-
situation.
Pardon?
And aware.
And aware of the
Rather than
situation.
secretive.
And child 1 is not living with parent. Child 1 is off.
Correct, and neither is child 2.
Okay. So if you're looking at bare title, right? If it is something with a survivorship interest, so joint tenancy with a right of survivorship, it would go to child 1 and child 2 would be out of luck. What,
Unless there's an offset.
pardon?
Unless there's an
Unless
offset.
there's an offset.
I mean, you get this.
Right, yeah. You see, particularly with bank accounts, where one child is added for the ability to just kind of help mom or dad manage their finances. A lot of time, the position that gets taken is, yes, there was, either a tenancy in common or joint tenancy, but that was for convenience sake only. And if you treat it as being for convenience sake only, then it passes under the estate plan.
Okay. Would it be recommended to create a property held in a trust?
Yeah, that's actually the better way to do it, is to have assets held in trust and have, child 1 is gonna be the one helping, have them be a successor trustee. And have them be, an agent under a power of attorney for property, and that way they can have access to help manage while mom or dad is still alive, but kind of declining. But it doesn't transfer ownership to child 1. It keeps ownership within the trust, and then it would divide out to the beneficiaries of the trust, which in most cases would be equally between child 1 and child 2.
Great, perfect, thank you.
Sure, yeah,
I just recommend it, I'd recommend having a lot of death certificates available.
yes, indeed,
And that's more.
yes, indeed,
They're way somewhere, or you got a copy somewhere, you gotta get rid of them.
yeah. So with death certificates, usually the funeral home will provide, 10 or 20, whatever you ask for and pay for. And a fair number of financial institutions will take a PDF copy of that death certificate, but it's amazing how many times you do need a death certificate.
The life insurance companies, they want the certificate, the seal on them and they
Correct.
want to mail everything. I mean, I'm executor and trustee for my dad right now and it's been a long journey, been a steep learning.
Any overseas security.
Oh,
Take months.
that's a whole other story. If you have foreign held assets, securities that are, Canadian companies, if you have actually direct registration stock with ComputerShare, here's my tip to all of you, get it out of ComputerShare. They are a nightmare to deal with, in terms of post-death. So while you are alive and competent, transfer it into a brokerage account instead of holding it direct registration with ComputerShare or a similar stock registration.
And attest that you're right.
Yeah, it's. Yeah.
My dad died 20 years.
Yeah, it's really hard and everything has to be medallion signature guaranteed. And then if the registration doesn't match by one period after an initial, it's just do it now while you're able to do it. And I had some individually owned stock that was ComputerShare and I went through the process with my broker to get everything transferred in and it was a hassle and like that's a financial services company and a rest of the state's lawyer. So.
And you had it transferred where?
I added to an existing brokerage account.
Okay.
Yeah. And that simplifies a lot of things. Because if it's, for example, the stock that I had transferred was a Canadian company. And so it was held by ComputerShare Canada, which required XBAR filing because I had a foreign financial account. So once I transferred it, I didn't have to do that anymore. It was all, it's all in one place. So definitely recommend that. Okay. So your typical estate plan will have a will, a revocable trust, beneficiary designation, and powers of attorney for healthcare and property. So that's kind of the basics. And as I said before, your beneficiary designations, you really want to make sure that they are coordinated with your overall plan. And my suggestion is when you do your estate plan, most estate planning attorneys will ask for copies of your, either copies or who you have designated, at least on a questionnaire, who did you designate for this account, this life insurance policy? And they will typically go through and recommend how you change a beneficiary designation to match your plan, so you're not inadvertently blowing up your plan with, a major asset that's held with a beneficiary designation. There are a lot of other components for more complex planning. A lot of people do gift trusts. It's a way to get property out of your estate, transferred to beneficiaries at a lower tax cost than waiting until that property appreciates and appreciates and appreciates and you die. And it drives up, potentially estate taxes. They can be structured so that ongoing income taxes are paid either by you outside the trust or by the trust itself. If you're paying the taxes, it's essentially another tax-free gift. And it's using some sections of the income tax code. A significant part of what estate planners do is kind of take the quirks of the tax code that don't quite work together, and utilize those gaps. So you've given away property, but you can continue to pay the taxes on it to benefit your beneficiaries so that the property that's in the trust just continues to grow tax-free, no expenses. Yes.
There's an annual limitation.
There's an annual limitation to annual exclusion gifts. Mhm. And then there's an exemption of overall estate and gift tax. And I've got those first in a second, we'll go over those. Another thing that you might hear talk about when you're doing more complex planning is generation skipping transfer tax planning or GST planning. So these are trusts that are often designed to continue for multiple generations. You know, maybe not just your grandchildren, but your great grandchildren and great great grandchildren. They can be created during your lifetime or at death. And they're designed to maximize the GST exemption that is available to you. So it's a way to, you know, if you have significant wealth, pass a chunk of it on to, for example, your grandchildren, and then pass other wealth on to children. And you know, you're trying to take advantage of the exemptions that you have. Insurance trusts are another pretty common use. So you have enough wealth that you are bumping up against the estate tax limits. And you have a lot of insurance. If you either transfer the insurance to a new trust and live 3 years, or a trust buys the insurance, either directly a new policy or from you, that insurance is not includable in your taxable estate. So it's a way to kind of shift things outside of, you know, kind of the assets that are subject to estate tax and pass them on to children or grandchildren or whomever. There's rigmarole with all of this planning, right? There are administration requirements. There are tax filing requirements. You know, it adds layers of complexity. And if you don't need to do the tax planning, you probably don't want to do this. You know, if you don't need to do estate tax planning, instead of a gift trust, you know, maybe you do a 529 account for grandchildren. But if you're at that level where you're going to be paying estate tax, maybe you do want to just fund a trust that could be used for education for your grandchildren. Yeah.
So I understand wanting to place assets that will appreciate in gift trust.
Sure.
What's the benefit of placing insurance in?
Placing insurance in a trust literally gets the proceeds outside of your estate for estate tax purposes.
So does it impact your lifetime exemption when you do that?
No.
But when you place things in a gift trust, it's what the value is that you place it in the trust.
Yeah. So if it's a new policy, and you're putting you have an insurance trust buying a new policy, you can fund the trust with the money to pay the premiums. That is part of the annual exclusion, assuming the trust has been drafted correctly. And then the proceeds, when they become payable, are outside of the overall lifetime exemption. So you've got a lifetime exemption, and then you've got this extra pot over here. The gift trust, you know, what you're giving to it is going to impact potentially, depending on how the trust is structured, either your annual gift tax amounts or your lifetime exemption, or both, depending on how big of a gift it is and whether there are withdrawal rights in it that would qualify for an annual exclusion. And that's a whole lot of complication that it's probably more than you guys need. Yes.
When was the generation skipping trust ever tax?
They would be subject to taxes. You can skip a generation. One, it can stay in trust. Depending on how it's structured, someone else might become the transfer for generation skipping transfer. But you know, you've got an exemption amount that skips the generation, so there's no tax at the death of your children.
It's a generation. That they rules, and then there's a trigger event, presumably a death, that would basically go to the next generation free of any state tax. And that would grow during their lifetime till their death. And then it would be subject to the state tax at that generation's.
Yes.
Wow.
So, it's a way to shelter and grow for that generation. And Illinois, for example, allows dynasty trusts, which can continue forever. It's a little complicated because, each trust, as the generation dies off, would then split for more people, and then split for more people, and then split for more people, and you can end up with small trusts that it doesn't make any sense to continue. But typically, if you're creating a dynasty trust, you're also giving the trustee the power to terminate a trust when it becomes too small to administer appropriately.
Thank you.
Sure. Okay, a couple other pieces that are often part of more complex planning. Private foundations, they are separate entities. It really only makes sense if you are doing significant charitable giving, because it is its own entity. You have to do accounting for it. You have to prepare tax returns for it. There's a lot of back office, kind of complying with the not-for-profit rules. For people who are charitably inclined, but not like huge charitably inclined, sometimes donor advised funds are helpful. It's a streamlined vehicle, like Fidelity Charitable is one of the really big donor advised funds. And it allows you to give everything in 1 year and decide, okay, over the next couple of years, these are the charities I want to, benefit in these amounts. And Fidelity will, do all of the back office accounting, tax preparation work, et cetera, for a fee. So they're often referred to as kind of private foundation light. It's basically offloading a lot of the work into a larger entity that can, they get the economies of scale. Yes, John.
Big benefit of either one is if you've got a year with a big chunk of income for,
Yes,
big capital gain or something, and you can say, well, we'll take half of that capital gain, and we don't want to give it away this year, but we can put it in a donor advised fund this year and take it back.
exactly. It allows kind of tax timing planning.
Yeah.
And yeah, it's a huge benefit, and you can give a significant chunk saying, I have to figure out where this is gonna go, but I can do that later.
Yeah.
At least I can get it, charitable. And I am gonna throw in a plug for Christchurch. There will be some materials coming out, I think after the first of the year, that will help if you want to include Christchurch as a beneficiary of your estate plan. They're in process and be out, I think, early next year. Yeah. So I've talked a little bit about exclusions and exemptions and all of this stuff. So every year, each donor, so in a married couple, both of the spouses can exclude $19,000 per beneficiary from gift tax. So married couples can exclude $38,000, and it can all come from one spouse, and they elect to split gifts, or each can individually make gifts of up to $19,000 per beneficiary.
But if you've got a child that's married, you can double it again.
Correct. You can give to your child, the child and the daughter or son-in-law.
You can give to anybody.
Yeah, absolutely. You can give to anybody you want. Right. Right. There are also unlimited exclusions for gifts to charity or gifts to a spouse, a U.S. citizen spouse. The other thing that a lot of people are not as aware of, which comes in really handy for grandparents, is the ability to make direct payments to providers of either medical services or educational institutions. So you could directly pay, for example, Northwestern, the full ride tuition for a grandchild and give that grandchild 19,000. So that's a really powerful way to kind of shift wealth generationally. Yeah, college tuition, exactly. It's huge. And when I was in private practice, I had a lot of clients who were paying their grandchildren's educational expenses, sometimes paid through grad school. Because they could do that. It took a burden off of their children and allowed their children to build their own wealth. And they got the joy of, being able to say, I'm paying for your tuition because I love you and this is important to us as a family. It's free. Tax free. Yes. When you die, the estate tax and GST exemptions are $15 million for deaths in 2026. Right now it's 13,990, but it's almost 2026. So, hold off. Married couples can obviously shelter twice that amount, but you have to do planning with marital and credit shelter type trusts. So it's a little more complicated to do it, but totally doable. If you're making gifts in excess of the gift tax exclusion, that 19,000 per person, that starts to reduce the estate tax available, the estate tax exemption. So if you make a, just for sake of easy numbers, $1,019,000 gift to someone, that 19,000 comes off the top, and the million reduces your exemption in 2026 from 15 million to 14 million available. Yes.
How does the IRS keep track?
How does the IRS keep track of that, all that stuff? Well,
You're required to report.
yeah, you are required to report. There are gift tax returns and estate tax returns, and you are required to report taxable gifts. You don't have to file a gift tax return if all you've done is made gift tax annual exclusion gifts, and you're not splitting gifts with a spouse. So there's no requirement to report any of that. But if you split gifts with a spouse, or you exceed 19,000 per person, or you're funding, you want to allocate GST exemption to a trust that is qualified for that. You might want to file a gift tax return just to allocate. So, yes.
But just to be clear, so if you gave $25,000 to one beneficiary, and you can split it, but then you would have to file a gift tax return
Yes.
to say we are splitting.
But if you gave 19,000 and your wife gave 6,000 to that same beneficiary, you would not have to split gifts, and you would not have to file. Yeah.
I understand that Illinois has a state tax.
Illinois does have an estate tax, and sadly, it's a much lower number. It is $4 million.
Per individual or per couple?
Per individual. And there has been talk. No, it's been 4 million for years.
And part of the problem, I think, is if you make, it's not an incremental, so if you're 4 million and $10,000, you're not taxed on the $10,000, you're taxed on the whole 4 million.
It's a progressive tax. They have been talking about that going away for a number of years. I know there are proposals out there. And it is a disincentive for wealthy people later in life to stay in Illinois, and a lot of people become Florida residents because of that.
Just as a time check, we have about 10 more minutes.
Well, that's actually, it's very good timing because the practical matters is the next session. So, yeah, Illinois, it's complicated if you're over 8 million, or if you're if your wealth is held unevenly between spouses.
So I understand that the estate tax is sort of a last die. You can give an unlimited amount to your spouse,
Correct.
and when you die, everything goes to your spouse, and there's no estate tax.
That's correct.
Implications. How, but then they're subject to the 15 million. Except you said that married couples can shelter twice that?
Right, they can each shelter 15 million. So the first spouse, at their death, let's say it's a fairly typical plan, I leave everything for the benefit of my spouse, and when both of us are gone, it goes to children. So at that first death, $15 million would go into what's either called a credit shelter or an exemption trust and be available for the spouse. Anything above that would go in a marital trust, available for the spouse. That marital trust would be subject to estate tax at the death of a surviving spouse. So in spending it, you spend the marital trust down first, and you keep that exemption trust untouched to the extent that you can. I've also seen this in Illinois, the surviving spouse, first spouse dies, marital and exemption trusts are created. There's a significant amount in the marital trust. And if the surviving spouse says, and I'm moving to Florida, because Illinois doesn't go back and say, well, but you died, the first spouse died, a resident of Illinois, before we have to tax it. So there's a lot of kind of post-death planning that can happen, but you don't know who's gonna die when, you don't know orders of death. You don't know if you're both gonna die at the same time in a common accident. I mean, so what your estate plan should do is try and cover as many bases as possible to maximize the amount that can pass tax-free to your beneficiaries. And do what is possible to reduce or eliminate estate tax at the death of the surviving spouse.
You may have already answered this, but if somebody moves to Florida, what does Illinois do? Claw back
Oh,
whatever assets were in transit, so to speak.
the question is asking if people move to Florida, what does Illinois do to try and, say, oh, this is still, anywhere, really. So Illinois can be somewhat aggressive. And when you move residences, if you maintain contacts in the state of Illinois, for example, a condo in the city, or your kids are here and you're up here, 5.5 months out of the year, there are concrete steps that you take to try and establish that no, you really are a resident of Florida, you are a visitor in Illinois. And it includes things like driver's license, voter registration, only claiming a homestead exemption in the other state, not in Illinois. Don't claim a homeowner's exemption in Illinois because it's not your primary residence, right? You're actually primary residence in another state. You want to make, people recommend that you establish a primary care doctor in the other place, even though sometimes Chicago is blessed with some excellent healthcare, and a lot of people want to hang on to providers up here. But if you have a primary physician in the new state, and they're the one kind of driving the bus, and maybe you come up here for something special, that's an easier argument. But Illinois will definitely fight the fight if they think it's worth it.
Also, estate taxes and affordability, it resumes.
Yeah. Yeah, you do. The Illinois estate tax is no portability, so you need to have at least, if you have $8 million in assets in a married couple, you need to have at least 4 million in each of their names. Federal, there is portability, so if one spouse dies and doesn't use all their exemption, that remaining exemption can be ported to the surviving spouse. There's a tax return that has to be filed and you claim it, and, there's some work around that, but it's not a use it or lose it. Illinois is a use it or lose it, and it's a much smaller number than the Fed. As I said, I think there will be a change at some point with the Illinois estate tax. It just, it doesn't track as many, it doesn't pull in taxes as much as you would think, because people do things like say, okay, now I'm gonna move to Florida, or I'm gonna move to, another state, South Dakota or wherever, that doesn't have an estate tax.
You know, what the tax rates for Senate?
Can I ask?
Oh, that's a good question. I do not remember what it is, because like I said, it's been about 15 years since I've done an estate tax return, but the way it's calculated, it kicks in with, $1 over. And Illinois does not have a gift tax, which is really helpful. There are some states that have state gift taxes. So you literally can deathbed give away assets to get under $4 million. And I have seen it and done it.
Directionally, it's the state tax exemption. Yeah, is it higher or lower?
It's actually the same, like, it's probably 10-12%. So the federal rate kicks in when you go over $15 million. And it's a graduated rate, so it starts to ramp up, and it gets up to, I think, about 37, something like that. So it's a lower amount, but the way they do the calculation is kind of penalizing.
You can.
Yeah.
You can basically give away assets on your deathbed, and that will not be added back to your assets for Illinois estate.
Correct. Yeah. Yeah, because Illinois bases, when you file an Illinois return, you're taking the number from the federal return and starting with the value of the estate at that. Now, if you're doing, there are some complications to deathbed giving from a federal perspective. So if it gets pulled in from a federal perspective, that complicates your Illinois, but
You got 6 to 7 million.
right, and you're giving, particularly if you're giving cash, that's a pretty quick way to kind of bring things down in Illinois so that you're under the 4 million.
And you get a credit for Illinois tax first against your bill. How does that come?
Yes, you do, and you have the option to either take that credit on the estate tax return, but if you are not required to file a federal estate tax return, you can take it as an expense for income tax purposes.
Unfortunately, we are just about at time. Are there any last questions?
Thank you.
Well, big thank you to Mary for everything. And just as a reminder, please do fill in your participation guide. And there are copies of last week's slides on the back table there.